Good morning, everyone, and welcome to our webinar this morning. My name's David Weston, and I chair the Bed and Breakfast Association. This webinar is about our class action against Booking.com. I'll introduce our expert panelists, Ben, Adrian, and Alex, in a moment. Firstly, who we are. The B&B Association is the UK trade association for B&Bs, guest houses, and small family-run hotels. We're members of the UK Tourism Alliance, and our sister body, the Scottish B&B Association, is a member of the Scottish Tourism Alliance. We celebrate our 20th anniversary next year. We're proud to have won industry awards for representing our members. We're here to inform, support, and represent our members. And wherever we can, we work together on shared issues with our friends and colleagues and other trade associations, for example, UK Hospitality, PASC, and ASSC, and others. This webinar is open to all accommodation providers who sold through Booking.com in the UK between 2019 and 2024, which make up the class, as lawyers call it, that we intend to benefit from the success of our class action. Today's webinar will set out to explain our legal action and answer the questions we've received so far, amongst the uniformly very positive reaction we've had from our members and others, as you can probably imagine. Firstly, this webinar is being recorded, so there'll be a recording available afterwards for you to watch again. And for those who've missed it. Secondly, there's a chat function on Zoom, which you can use to write written questions or comments, which we'll pick up later and try to answer some of the questions we received during the webinar, as well as questions we've already had. And we'll follow up on comments afterwards. We'll read all the comments you make. Secondly, a bit of background. Over the last nearly 20 years, the B&B Association has campaigned on behalf of accommodation owners against some of the more egregious practices of the big OTAs, online travel agents. As our members will already know, back in 2017, we filed 5 formal complaints about Booking.com with the CMA, the UK competition watchdog. One of our complaints was about rate parity restrictions, the subject of our current class action. The others included issues like false discounts, false availability statements, misleading and non-transparent default search rankings, and brand jacking, the forced bidding by OTAs on hotel and B&B names with search engines. And at the time, the CMA did take action on some of those issues. So there's a long history leading up to the legal action we'll be explaining in a moment. And as you can imagine, we were absolutely delighted a few weeks ago to have been able to announce that we had secured funding for this UK class action. And our legal team and economics experts have been working on the claim for many months. Although the action will be in our name as so-called class representative, we're bringing it on behalf of every business, large and small, who sold their accommodation through Booking.com anytime between 2019 and 2024. So today I am here on your behalf. What's our class action about? Our legal experts will explain in more detail in a moment, but the essence is that we believe Booking has engaged in anti-competitive practices, including so-called wide price parity restrictions, which have enabled it to charge excess commissions at your expense. We aim to convince the Competition Appeals Tribunal, the CAT, of our case and ask the court to award damages for recompense in your favour. Today, I'm joined by 3 legal experts from Stephenson Harwood to guide us through the claim and answer your questions. They are Ben Sigler, Adrian Carr, and Athanasopoulos. So I'll hand over to Ben, I think, initially to talk through the claim, and then we'll move on later to questions. Thanks. Over to Ben and Adrian and Alex.
Thank you, David. And a further thank you to all of you for joining us today to allow us to introduce the proposed claim against Booking.com, on which we're delighted to be working with the B&B Association. So I'm Ben Sigler. I'm a partner in Stephenson Harwood's commercial litigation team, and I'm here with my colleagues Adrian, Carr and Athanasopoulos, two of the core members of the wider Stephenson Harwood team who are supporting the Bed and Breakfast Association on this claim. By way of a little background about our firm, Stephenson Harwood is a leading international law firm which has been established for nearly 150 years. We have more than 1,400 employees worldwide, including 210 partners, working from around a total of 8 offices across Asia, Europe and the Middle East. Most notably, from the perspective of this claim, we're recognised as a leader in group litigation. Our team has led several other group claims in the Competition Appeal Tribunal, more commonly referred to as the CAT, as David's identified. Those include the merchant interchange fee umbrella proceedings, where we represent more than 1,800 companies in group claims against Visa and MasterCard in relation to interchange fees. We've successfully secured settlements for our clients in that perspective. We're running a claim for supermarkets arising out of the salmon cartel. So we're representing 7 of the UK's supermarkets in a group claim against Norwegian salmon producers in relation to alleged cartel in relation to the market for farmed salmon. And finally, and most pertinently, we're acting for ACSO, which is the Association of Consumer Support Organisations, in a claim against Amazon in relation to alleged anti-competitive price parity policy. So relatively similar in terms of factual issues to those which are engaged by this claim. And again, that's proposed collective proceedings before the Competition Appeal Tribunal. So beyond the Stephenson Harwood team supporting the B&B Association on this claim, the wider team also includes, amongst others, specialist barristers from Monkton Chambers, namely Robert Palmer KC, Alan Bates and Hugh Whelan, and also economic consultants at Fideras Partners, with whom we frequently worked before in both cases. I'll now hand over to my colleagues Adrian and Alex, who will provide you with some further detail about the claim and the way that the CAT approaches claims of this nature more generally. And as David said, we'd be delighted to address any questions that you may have, either during the course of this webinar, or if you want to get in touch with either David or us separately via email.
Perfect. Thank you, David, for inviting us to this webinar. As an introduction, I'm Adrian Carr, an associate in Stephenson Harwood's Group Actions and Competition team. I'm very excited to be working with the Bed and Breakfast Association on this claim. In this talk, I'm going to start by providing an outline of who the claim is being brought against and why it is being brought. We're then going to provide a bit of background on the UK Competition Appeal Tribunal, which is the forum in which this claim will be brought, and the collective proceedings regime under which the claim will operate. This hopefully will help develop your understanding of what the Bed and Breakfast Association's role as proposed class representative will be, the role that their supporting team will play, and in turn provide you with an indication as to how the claim will impact you as members of the Bed and Breakfast Association. Turning first to who. So the claim will be brought against online travel agency Booking.com. While there are other travel agencies such as Expedia, this claim is not focused on them. As David mentioned, this claim will be brought on behalf of UK accommodation providers that have been active on Booking.com's platform. Now, I should clarify that accommodation providers includes not just bed and breakfast and guest houses that are members of the Bed and Breakfast Association, but all accommodation providers, including, for example, hotels. In short, the Bed and Breakfast Association will allege that these accommodation providers have suffered an unlawful overcharge by paying Booking.com's artificially inflated commissions. To provide a bit of background, the claim concerns price parity policies. Broadly, you get 2 types of price parity policies. These are called narrow and wide. Narrow price parity policies prevent sellers from offering lower prices on their own direct sales channels, but the sellers are free to offer low prices on third-party channels. Wide price parity policies, by contrast, restrict sellers from offering lower prices on any sales channel, including both their own direct sales channels and those of third parties. Now, the Bed and Breakfast Association's claim arises from Booking.com's wide price parity policies. Essentially, these prevent or strongly discourage accommodation providers from charging lower room prices on other sales channels, such as those of other online travel agencies or the accommodation provider's own sales channels. This is the case even where the costs of selling through those other channels may be lower. Now, if accommodation providers do not comply with Booking.com's wide price parity policies, this impacts their visibility on the platform. They therefore stand to receive a lower number of reservations than they would otherwise receive if they did comply with the policies. Since accommodation providers are prevented or strongly discouraged from charging lower prices on other sales channels, Booking.com is protected from competition, and it's able to set its commissions at anti-competitive levels. If it were not for Booking.com's wide price parity policies, then accommodation providers would be able to offer lower room prices on other sales channels, diverting sales from those other channels to those other channels and applying competitive pressure on Booking.com to reduce the commissions that it charges. Now, I should note that Booking.com has in the past been subject to regulatory scrutiny in connection with its wide price parity requirements. Notably, in July 2024, the Spanish Competition Authority fined Booking.com 413 million euros in connection with the imposition of a series of wide price parity policy obligations on accommodation providers. Furthermore, in August 2024, the Italian Competition Authority preliminarily concluded that Booking.com's wide price parity policies were anti-competitive. Then, in September 2024, the European Court of Justice preliminarily ruled that price parity clauses, both wide and narrow, are not objectively necessary for the implementation of Booking.com's online hotel booking platform and are not proportionate to the objectives pursued by the platform. There is therefore a long series of regulatory scrutiny in respect to Booking.com's conduct. Now, we're now going to turn to the collective proceedings regime that operates in the CAT, and I'll turn to my colleague Alex to provide a bit of background there.
Thank you, Adrian. So these proceedings will be brought in the form of what are known as collective proceedings, or a form of class action before the UK's Competition Appeal Tribunal. The UK's Competition Appeal Tribunal is a specialist tribunal based in London that hears disputes in relation to breaches of competition law. Collective proceedings were introduced as part of the Consumer Rights Act in 2015. And what collective proceedings allow a class representative to do is to combine many thousands or indeed millions of individual claims. So in this case, we're saying that individual UK-based accommodation providers would have individual claims against Booking arising from the unlawfully inflated commissions, and the Bed and Breakfast Association, as the proposed class representative, would be seeking to combine all of those claims into one set of collective proceedings. Collective proceedings are initiated by what we refer to as a class representative. A class representative is essentially the figurehead of the claim who is responsible for acting in the best interest of the class, so in this case, the interest of UK-based accommodation providers. Collective proceedings can be brought on an opt-out or an opt-in basis. These proceedings will be brought on an opt-out basis, which means that UK-based accommodation providers who marketed their properties on Booking.com will not have to take any steps to actively participate in the proceedings, which is one of the benefits of this regime compared to the regimes that prevail in other jurisdictions in Europe or the United States or Canada, where class actions are quite common. One of the benefits also of collective proceedings is that the claim itself is funded by a litigation funder that will cover all of the costs of the litigation, and class members will not have to pay anything in order to participate in or benefit from the class actions. Furthermore, individual class members will not bear any adverse cost liability, which means that in the event that the claim is unsuccessful, individual class members, so individual UK-based accommodation providers, will not have to pay any of booking's adverse costs, which is another benefit of this regime in providing protection for the individual class members, themselves. So that is the collective proceedings regime in a nutshell.
Thank you, Alex. So, as Alex noted, the Bed and Breakfast Association is going to operate as the proposed class representative in these proceedings. Now, the Bed and Breakfast Association is the UK trade association for bed and breakfast and guest houses, but as we have noted, the proposed class extends beyond those types of organizations, extending to all types of accommodation in the UK. As David touched on as well, the Bed and Breakfast Association has a long history of having campaigned against the anti-competitive conduct of Booking.com. That includes them having made these formal complaints to the Competition and Markets Authority, including on price parity matters back in 2017. And as Ben also outlined at the outset of this meeting, the Bed and Breakfast Association has instructed and will receive substantial support from an experienced team of barristers, solicitors, and economic experts. So then this brings us to the question of what can you, as members of the proposed class, do at this stage? Now, we've said that the proposed class will include all eligible UK accommodation providers. This includes, in particular, small independent B&Bs and hotels. Crucially, these being opt-out proceedings, eligible class members will not need to sign up to participate. Anyone who falls within the class definition and has not transferred their claim to another party will be included in the claim unless they specifically opt out. Individual class members will not be named or otherwise identified in these proceedings. Furthermore, as Alex noted, the Bed and Breakfast Association has obtained funding, and eligible class members therefore will not be expected to contribute financially to the proceedings. Instead, the claim will be driven for by the Bed and Breakfast Association. As proposed class representative, they will, amongst other things, act in the best interest of the class, be responsible for the strategic and procedural decision-making supported by the solicitors, barristers, and economic consultants that they have appointed, and throughout the proceedings communicate with and update the class members. Now, in due course, a claims website will be created through which further information will be communicated to the proposed class. In the meanwhile, however, you will be able to refer to the Bed and Breakfast Association's own website, the details which are set out on the slide. You're also able to go and submit any queries that you may have to the website, to the web address that's set out on the slide here. And now we can open the floor to any questions.
Well, thanks very much for that, Ben, Adrian, and Alex. I think that the first thing I'd just like to add is the key points we want to get across to everyone watching is that you, as a member of the class that we're fighting for, don't have to do anything. You don't have to register anywhere to be part of the claim. You don't have to take any action. Secondly, that you won't be identified to Booking.com. Your name won't be part of this in any way. We, the Bed and Breakfast Association, are the class representative taking this on your behalf. And the third thing is that there's no cost to you as members of this class. You'll be fully funded. To me, those are the three key things to take away from this morning. One thing to, just looking at questions, somebody asked about self-catering. I think, yes, as Adrian was saying, that this class is everyone who was as an accommodation provider selling through Booking.com between 2019 and 2024, and that could be a self-catering business, it could be a hotel, it could be a B&B, it could be many types of businesses, as long as you were selling through your accommodation through them to consumers and you're based in the UK, then you're covered. It's certainly not just members of the B&B Association. We are here to represent the entire group of everyone who was selling through Booking, no matter what their type of accommodation is. Another one I shall ask colleagues to answer is you mentioned the Spanish Competition Authority fine and the ECJ ruling about EU competition law. How relevant is that to UK law and the CAT? Is now law quite similar?
Thank you, David. So European and UK competition law are very similar, but the decisions in Europe and Spain, being post-Brexit decisions, are not binding. However, they do provide an indication that this is UK and EU competition law are very similar. So even though the decisions may not be binding in the UK, they are indicative that there is very likely to be a finding of anti-competitive conduct in the UK were a claim of a similar type to be brought here.
And I think it's worth just adding on that point, David, that there's a range of proceedings being pursued across Europe. So there's a claim in France of a similar nature, there's a claim in Spain of a similar nature, there are claims in the Netherlands of a similar nature. So this is certainly not by no means the only claim which would be predicate on the same facts. Ultimately, various different other enterprises based on the same issues have arisen and on the same theory of harm. So we're very confident that we'll be able to demonstrate to the CAT's satisfaction that Booking did behave in an anti-competitive way.
Thank you. Thank you. Yes, and Chris was asking on the chat, approximately, can we say anything about what proportion of any award would be taken in fees from the award as it's made?
So I think on that issue, ultimately, it's a very hard thing to describe in the abstract, because in broad terms, it would depend on the amount of the damages received and or any settlement which was agreed. Ultimately, in entering into a funding agreement, the class representative agrees a waterfall with the funder and the other interested parties, so the AT insurers, the lawyers, the barristers, etc. The important point, I think, for class members to note is that the CAT retains an absolute discretion as to whether that waterfall should be adhered to. And we've seen in recent decisions, which the CAT's given, that ultimately its principal concern is to ensure that the class members get fairly recompensed. So I think, over and above the fact that you as class representative will ensure that that happens in any event, the class representatives can be, class members can be comforted that the CAT will make sure that their best interests are always looked after at all times.
Thank you, Ben. And yes, just to add from our point of view as the B&B Association, obviously we several times over the last few years, we'd have liked to have brought this kind of action ourselves, but as a very small trade association, non-profit, where we were never in the position to do so. So it's only by this form of funding that we're able to bring this action at all. So I think people should bear that in mind, that yes, the legal team will get recompensed in the end, but if we hadn't had this form of funding, we simply wouldn't have been able to bring this case at all. So that is a key thing to think about.
Let me just add a couple of points to that as well, David. I think it's important that everyone appreciates the funding structure itself is scrutinised at various different points during the process, including at the point at which you seek certification by the CAT. So the CAT will have jurisdiction to consider the terms on which the funding is being granted and the terms on which the various different parties are acting to ensure that the class are being properly treated in that context. And And of course, we're confident that we've got excellent terms of funding here, and the CAT will consider those terms. So again, class members can be comforted that the court will be considering that as part both of certification and then subsequently as in the context of any distribution of damages or settlement proceeds.
Great. Yes, thanks, Ben, for clarifying that. Yes, and there's a question. There's an opt-in claim in the Netherlands supported by HOTREC, a European hotel association, which also covers the UK. Can we comment on the differences briefly between that and our claim?
Sure. So as we understand it, I believe the HOTREC claim window has closed. So I don't believe they're taking additional members. But we put out through the Bed and Breakfast Association's website a short FAQ addressing this issue in some detail. So I won't go through the full analysis in that regard. But I think there are 5 principal differences between our claims. I think the most fundamental one is in order to participate in that claim, you assign your interest to a stichting, which is a Dutch structure, which will then pursue the claim on your behalf. You're obliged to identify yourself. You're obliged to provide various different information. So basically, an inventory is a sort of set statements which demonstrate your dealings with booking over time, and which will found the basis of a claim for loss. There may be also there is, as we understand, also an obligation to provide evidence on an ongoing basis to the extent that the stichting requires it to prosecute the claim. There is a contractual agreement between the stichting and the class members as to the shares of damages received. So I don't know, again, not being a Dutch lawyer, I can't comment on this, the extent to which the Dutch court has the same extent of jurisdiction to consider the parties' contractual agreements and decide whether or not the contractual agreement should be upheld or otherwise. So important point for people who are still on booking is that booking will be aware that you're participating in that claim necessarily. And obviously our claim doesn't involve any need to identify oneself. All of the claims brought through a representative. That claim obviously engages issues relating to multiple different jurisdictions. Our claim is solely focused on English law issues. English law issues won't be an afterthought in it. They'll be absolutely central to it and will be the principal focus of it. It will be determined by a specialist tribunal, which will be dealing with these issues, and is all that tribunal deals with. And we think it will be dealt with more expeditiously accordingly. I think any other points you guys want to add?
Well, furthermore, one of the points that we touched on when we were discussing the collective proceedings regime is that these claims can be brought on behalf of a large group where there's a common interest, essentially, or a common theme to the claim. What that means is that the individual claims of class members do not need to be determined separately. Claims are determined collectively. So damages can be worked out on an aggregate basis. You don't need to go into the individual losses suffered by each and every class member. So one of the advantages of this regime, which was established recognizing that it may be unduly burdensome on individuals to bring claims separately. One of the advantages of the regime is that they don't need to bring this claim separately. They can bring them, or a class representative can bring claims on behalf of a large class, such that they don't have to have their claims determined individually. So that means they don't have to submit their own individual evidence of their losses. It promotes efficiency and access to justice.
Thank you. Yes, thank you, Adrian. And that sort of answers points that were raised on the chat by Jonathan and Roland, who both asked similar questions. Would we need to pass on invoices or information about how our bookings split between booking.com and others to take part in the claim? No, none of that applies, because as Adrian just said, we're bringing the case overall on behalf of the whole class, and we're working out, and we've got economic experts who are working out the financial damage to the whole class. So you as an individual business do not have to give us financial information about your business at all. We will work that all out on the basis of figures, facts and figures we know. We won't need information from you about your specific business. And that's one of the differences, as Adrian says, with the hot rec claim, which is now closed, and our claim. One other question that's come up on the chat is, what are the outcomes being sought? I mean, we're obviously say we're asking for recompense for the overcharge of commissions. Are we asking for Booking.com to stop engaging in certain in these practices?
Yes, in short. So we'll be seeking damages and injunctive relief which restrain them potentially from continuing to pursue this anti-competitive conduct.
Booking has already seized the conduct in Europe in response to regulation that came in, the Digital Markets Act, last year. So it may be that injunctive relief is not necessary, but it is certainly an option in the event that Booking has not seized the infringing conduct in this jurisdiction in response to that regulation in Europe.
Thank you. Yes, that's clarified that. Somebody asked, how can you say, how are we saying commissions overcharged when they see on their invoices from Booking the exact amount of commission and that is what they paid? This is a big one that takes us into the sort of essence of the claim, and my brief non-legal answer is that, as we were saying earlier, our case is that through their anti-competitive restrictions on what you can charge elsewhere, Booking have effectively been able to charge commissions that were higher than they would otherwise have been able to charge. So overall, it's been an increase. Whether or not the actual amount of commission on any individual booking it was known in advance. I'm sure one of my colleagues, legal colleagues, will put that in much better wording.
But that was great. So it's right. So we're not alleging that in relation to individual invoices or individual properties, a commission was charged that was improper or in any way fraudulent or anything like that. What we're saying is that the price parity policies made it much more difficult for competing online travel agents to compete with Booking on retail price and commission. So what we're saying is that absent the price parity policies, Booking would face much fiercer price competition from competing platforms, which would essentially force it to charge lower commissions than it is in this factual world. And we can unpack that a little bit in a very simple way. So a competing online travel agent wants two things, right? It wants guests and it wants suppliers like guest houses and hotels. And the ordinary course would be, in order to compete with, let's say, Booking, the competing online travel agent would essentially go to the supplier and say, hey, I can offer you lower commissions, and in response, you can charge a lower price on my platform. In turn, that would mean that guests would over time learn that they can find a cheaper room on the competing online travel agent. And in turn, that would impose competitive pressure on Booking to charge a lower commission because it wouldn't want to lose the sale on its own platform. However, because of the price parity policy, which essentially prevents the supplier, the UK-based accommodation provider, from offering a lower price on that competing online travel agent, that competition that you would ordinarily see on the level of Booking's commission is alleviated. And therefore, Booking can overcharge and charge a higher commission than would prevail in a truly competitive market.
Thank you. That's great. By the way, just looking through the questions online that you put on there, There's quite a few which are basically comments and thanks, and appreciating the fact we've taken this action. So thank you for those. Appreciate all those positive comments and all the other ones we've had by email. So yeah, thanks for your kind words. There's a question from Chris. What do you hope will be awarded, and how will this be split between guest houses? Well, the first thing is obviously it's not just guest houses, it's all those types of businesses, hotels, B&Bs, guest houses, self-caterers, everybody. But the question of what we hope will be awarded is a very difficult one to address at this very, very early stage. I don't know if my colleagues have anything that we can say on that.
I think this all gets addressed in terms of expert evidence when we provide our evidence as part of the certification process. But it suffices to note that we consider the effect of this anti-competitive conduct runs into the hundreds of millions, if not billions.
Thank you. Yes. So yes, and so in terms of how that, and what we're hoping is obviously that the CAT, the court concerned, will make an award, as other jurisdictions have on similar legal backgrounds. We hope the CAT will make an award in the UK in favour of the whole class, and then that award would then be distributed amongst all of the class, and including all of the businesses, large and small, that we've been talking about. That's a complicated process, and this is the start of a long process. But that's what we're here to be fighting for and to be claiming on your behalf, so that some of these overpayments of commission, which you shouldn't have had to pay and have already paid, will hopefully, we'll be asking the CAT, the Competition Appeals Tribunal, to say that they were overpaid improperly and because of anti-competitive conduct, and ask for those to be, or for a payment to be made to those businesses.
Just on the point of distribution, David, just so that people are clear, as part of the process of certification, we will be proposing a distribution plan to the court, which the court will then consider, and that will be prepared in conjunction with expert claims distributors. So I think ultimately the court will have sanction not only over the way the damages are distributed in terms of the proportions that they go to the various different interested parties, but also the manner in which they're distributed. So again, not only can class members have confidence that you'll be giving that oversight, but they can also have confidence that the court will give that process oversight and make sure it's fit for purpose too.
Okay, thanks, Ben. James asked, if the claim is successful, would there be payments from booking to individual accommodation providers? And how would these payments be calculated? Number of bedrooms, number of bookings, length of time on booking.com, whatever.
So the way that things will be ascertained by the court initially is on the basis of what's described as a broad act principle. So when analysing damages, the court will analyse damages in the round and how the affected class has been affected by the alleged infringement. Once the absolute number is established, and obviously the interest that's been calculated on the amounts that should have been paid over time, the amount will be effectively fed through the distribution plan, and the court approved methodology for distribution between the various different parties will be affected, and again, in a sense, in a broad sense, it will be distributed according to the value of loss that each party has suffered, and that will be computed on a basis along the lines of the one which you discussed. But again, the court will be sanctioning that process, and so again, all of the documents which are produced in the context of our CPO application will ultimately be available and will be shared on the claims website. So individual class members will be able to analyse that information themselves and raise any questions they might have with us, obviously, as the class's lawyers, and or with you as class representative.
I'd also just say, I think in terms of the practicalities of distribution, which I appreciate are very complex, as Ben mentioned, we'll be working with a specialist claim administrator that has a lot of experience distributing damages arising from class actions in the United States and Europe. So practically speaking, we expect that there'll be a sequence distribution model. So we expect that, or we hope that we will be able to use bookings infrastructure in order to try and improve distribution. So for example, by assisting with notification or the actual payment of available claim proceeds. And then every hotel or accommodation provider will have an opportunity to come forward and claim damages. And it may be that different accommodation providers that have varying degrees or levels of evidence will be able to receive different amounts. So for example, you may be able to receive a certain set amount if you no longer have a booking account, for example, and don't hold any evidence. But if, for example, you're able to provide more evidence of your interactions with booking and, let's say, invoices that reflect the commissions, you may be able to receive a more precise amount, for instance. So that, again, just goes back to what Ben was saying, that the tribunal will adopt a broad brush approach to make sure that practical justice is achieved, and will not be overly focused on extreme precision if doing so would deprive UK-based accommodation providers of the compensation to which they're entitled.
And again, I think, and Alex has touched on that in that very helpful amplification, which is both you as class representative and the court will have oversight of this process, and the process will be designed in a sort of utilitarian, on a utilitarian basis, so that as Alex said, it's not about absolute precision, it's about giving the greatest justice to the greatest number of people.
Thank you. Thank you. And Peter was put on the chat, in view of other claims being made against Booking.com, will there be any money left for them to pay out damages or to our claim, or will they go bust? Well, obviously, I can't answer for whether Booking will go bust, but I would personally say it's not hugely likely. My understanding is their market capitalization is 240 billion of that order, which is about equal to the biggest 5 global hotel groups combined. So my personal opinion is I don't think they're very likely to go bust because of our claim, but we can't promise anything.
I would say that's a vanishingly low probability, and I would also add that one of the principal issues that concerns funders at the moment they look at a claim is whether or not a defendant would be capable of meeting any damages or award which is made against it. And so the funder in question will have done detailed consideration of that and wouldn't have funded the case if they had any concerns in that regard. I don't personally have any concerns.
No, thank you. Just trying to pick up a few more questions. Josh has said, do you have to be a paid up member of the B&B Association to be included in this claim? No, emphatically no, you don't have to be a member. You don't even have to be a B&B. You only have to be a UK accommodation provider who sold through Booking.com between 2019 and 2024. One person has asked what will be the time frame. I don't suppose it will be only a few weeks, as the case is not filed yet. So approximately how many months or years is it going to take? I don't think we can give a definite answer, but Ben, what would you say?
No, absolutely not. I mean, I think the timeline to certification, which is the first stage in the process, which is our making an application to have effectively the claim admitted and to have you appointed as class representative on behalf of the class, is probably going to be around a year. Initially, this regime, as Alex identified earlier, is relatively nascent. So there were a lot of appeals from certification decisions. We're seeing less of those now. So on the assumption that there isn't any appeal from the certification decision, you might see trial another year or two after that. So in the round, this isn't going to be a short enterprise. It's going to be an enterprise that spans a number of years. And again, of course, as is incumbent on you as class representative and us as the solicitor supporting you, we'll obviously be looking for any opportunity to achieve an early settlement which is favourable to class, and we'll be mindful of that throughout. And so again, whilst we hope that that kind of resolution might be achievable, we have to prepare and are prepared, and the fund is prepared to go all the way with this one as is necessary.
Thank you. Yes, and somebody was commenting that it's not so much just the compensation as much as getting Booking.com to play fair, which they've never done, this commenter says. Well, I think, as we said earlier, we'll be asking for them to cease anything that they're continuing to do in terms of anti-competitive behaviour, but they have already ceased some of it, as was said earlier. And as I said at the beginning, when we made our complaints through the CMA did make rulings on some of the issues we asked for, separate to the ones we're talking about today. So some action has been taken. So they have stopped doing some of the things that the industry has complained about over the years. So these things can work. People are asking, several people are asking versions of the same question: do we have to sign up to anything? And we've said no, because we're representing the whole class. A couple of people have asked versions of a question: how do you know who to send money to if the court find in your favour? I think we've touched on that, but just perhaps we should clarify that a bit then, because we're talking about, Ben, you've taken that.
Yeah, so that will be dealt with through the distribution process that we described earlier. So ultimately, the court will approve a distribution plan, and the distribution plan will deal with how this is dealt with. And as Alex said, we hope to be able to use some of Booking's infrastructure in that context. But there will be a claims administrator appointed who will deal with the distribution of claims to the various class members on your behalf as proposed class representative.
Thanks, Ben. Paul has asked, what would happen to owners who might be retiring, or who might, various other people have asked a similar question, if they don't own their business anymore, if it's been passed on or whatever, would the compensation go to the new business owner?
So long as you were active on the platform within the relevant claim period, you should be entitled to participate in the claim, provided that you haven't gone and assigned away your right to pursue the claim or any claim proceeds that might arise from it. So as a general position, the fact that you no longer operate a B&B or other accommodation wouldn't preclude you from being a class member in this claim.
And again, I think in a sense, if the question is, I owned a B&B and that B&B was owned through a business and I sold the business to someone else, well, the claim lives with the business that was operating the B&B. So to the extent that you have sold your business, then you wouldn't have an entitlement to participate yourself. The business is the proper claimant to the claim.
Thank you. Sinclair has asked, if this is successful, will the ruling likely mean that other OTAs like Expedia will need to amend their price parity clauses too, if currently they have them in place?
I would expect it would have an effect across the market, and as Alex has described, to the extent that this behaviour ceases and a competitive market is established, we would expect to see commissions coming down, and that's the theory behind our case.
Yes, we'd very much like to hope to make sure that all the big OTAs play fair by their partners, accommodation owners. And that's one thing we've always said as the B&B Association. We'd like to try and redress the balance a bit in terms of power between the big OTAs and small accommodation owner businesses. So this class action is part of that whole process. I don't think we've got time to take any more of your questions, but thank you for them all. We'll look through all the questions after this and see if we can respond on our site later to anything that hasn't been addressed during the webinar. But and we'll wind up in a second, but I just wanted to emphasize again the sort of three key points, because A lot of them have come up in questions, but the 3 key points I think to take away is you don't have to do anything to take part in this claim. You don't have to register. You don't have to give your name. You don't have to give any financial information. You just have to be somebody who sold through booking.com through those dates. You won't be identified to booking.com. Your business won't be on a list of people who have brought this action. So don't worry about that. And there's no cost to you as businesses. The costs are funded by a financial institution. So you don't have any cost for this claim. And we are bringing it on your behalf, acting for a whole class of hotels, B&B, self-caterers, guest houses that sold through booking.com between 2019 and 2024. As we said, we'll be putting up a claims website, which is ukbookingclaim.com. That's not ready yet, but it will be. And this is the start of a very long process. So what we're wanting to do is create a dialogue with everybody who we're representing, pass on information about the claim as it goes forward. And so that's what we'll be doing, and working with our friends and colleagues in other trade associations, notably the UK Hospitality, PASC, ASSC and others, in informing the whole class of what we're doing on your behalf. So I think that covers everything. I'd just like to thank you all for attending. Keep an eye out on our website and on the claims website for more information as it goes forward. And I'd like to very much thank Ben, Adrian and Alex for their participation, their help in this webinar and explaining everything to us. So thank you guys. And if you want to say thank you.
Thank you for having us, David. And as we said at the start, we're absolutely delighted to be working with you on this, and delighted to be supporting the class members in this context.
Yeah,
Great.
Thank you very much for inviting us, and look forward to working with you on this.
Thank you, and thanks everybody, and goodbye. Thank you.
Yes.